What is the writing requirement for certain electronic records? Primarily, some records, as part of its storage and use process, requires that the record be in writing. And the purpose of this is to evidence the terms of the writing or what is contained in it, so as to avoid any instance of fraud. For example, under contract law, the Uniform Commercial Code, Section 2-201, it commonly referred to as the statute of frauds, requires that some forms of contract be in writing to be enforceable. This is simply a good example of a type of record that if you are going to use that record in a way that is enforceable, that it is acceptable, that it is in the prescribed format, it must be in writing. So there are other records, once again, perhaps administrative filings, perhaps evidence of ownership, perhaps commercial paper, that are required to be in writing in order to be useful in their intended purpose. With that being said, it begs the question, what is a writing? Well, the question is resolved between two statutes at the federal level. First, and I'll read this, 15 U.S.C. United States Code 7001A1 reads, "A signature, contract, or other record relating to such transaction may not be denied legal effect, validity, or enforceability solely because it is in electronic form." So a contract or other similar documents evidencing a transaction, if it is in an electronic form or an electronic record, it is valid. What is a record? That's answered in 15 U.S.C. 7006A9, which reads, "The term record means information that is inscribed on a tangible medium or that is stored in an electronic format or other medium and is retrievable in perceivable form." Taken together, almost any form of saved document is a record, and a saved document is enforceable and cannot be denied enforceability simply because it is in electronic format. So collectively, these are the requirements and the resolution or definition of what is a writing for purposes of a valid electronic record.